Okay, now we're going to move to item 4, approval of the minutes from November 7th, 2025. Excuse me?
Let's ask if y'all voted on the agenda. The last vote was on the agenda.
We did.
Yeah. The first vote was on the agenda.
That's right. We kind of did it flipped.
Yeah.
Okay, item 4, we're going to approve the minute. Can I have a motion to approve the minutes from November 7th, 2025? Motion. We have a second. Any discussion from this board? So we're going to open it up for public comment. I believe we have a member, so you have the floor, sir.
Mr. Morris is just going to give you guys a handout real quick. Yeah, sure. So basically, it's a copy of the minutes with changes shown in bold and underlined on page 2 and the bottom of page 3 and the top of page 4. I'm good. All right. Good morning. So there are some issues with the minutes as written that I would like to bring to your attention. Attorney General Opinion 8247 states that minutes are meant to be a brief.
Yes, sir. It was my fault. I'm brand new. I did have a good point brought up. I'm not going to take away any of your time, of course. Can you introduce your name and who you represent?
Yeah.
For the record.
Yeah. So my name is Ethan Ream. Basically, I'm a fossil hunter. I've been coming to these meetings for about a year and a half. Born and raised here in Tallahassee. So Attorney General Opinion 8247 states that the minutes are meant to be a brief summary or series of brief notes or memoranda reflecting the events of the meetings. Thus, it doesn't need to be verbatim, but it must be written in a way that is properly reflective of material discussion that has or may affect decisions. So on page 2 of the minutes, Dr. Wilford's bar updates completely omits the occurrence of 8 minutes of discussion between commissioners in regards to the fossil permit program. Multiple members stated their desire to completely eliminate the program, and Commissioner Kaufman requested Dr. Mayar provide an update on looting / the fossil permit at this meeting. Further, Commissioner Phelps and Chair Bentz requested staff return with a report on the fossil permit program in order to eliminate it. As shown by the Attorney General's opinion, the discussion must be included given its possibility or likelihood to affect future decisions. On the bottom of page 3 and the top of page 4, the public comment portion of the notes currently states, Ethan Ream was recognized to comment. He spoke about previous archaeological looting cases and in support of the state's fossil hunting program, which is managed by the University of Florida. He also alleged sunshine law violations at the meeting, which were rebutted. This is a strong misrepresentation that is legally incorrect. So first, I did not speak about random archaeological looting, but instead how DHR has weaponized ambiguities in Chapter 267 to hunt citizens. Archaeological looting cases in the context of previous bar program reports mean something totally different. As I said, the minutes state that he alleged sunshine law violations, which were rebutted. I'm not sure yet who wrote or approved these notes, but the summary as it sits is misleading as it fails to convey the substance of the allegation, and the public cannot reasonably understand the nature of the claim. The use of the term rebutted is false, and I would argue illegal, as the definition of rebut is to claim or prove that evidence or an accusation is false. To the contrary, Commissioner Kaufman confirmed the conversation with Dr. Bentz did occur, and they were discussing the fossil permit program offline. The Sunshine Law Manual states, in order for a violation of FS 286.011 to be present, you need the following: a meeting to have occurred. There is no such thing as a simple pass you in the hallway, information gathering or sharing by 2 or more government officials, and the Attorney General's manual has held that any such innocuous meetings have been held to be illegal. Second, you need commission business to be discussed. It was confirmed twice by Commissioner Kaufman that such an innocuous meeting did occur on break, and that a known hot button topic, which was raised earlier in the meeting, was discussed offline because they knew I was going to push back during public comment. 30 seconds. Finally, you have intentionality. Although this is not necessary to violate the law, it is an aggravating factor. They were talking in hushed tones in an unused side room, and then Commissioner Kaufman told Chair Bentz to go in first. exiting the room about 30 seconds after Chair Bentz. Thus, obvious intent to hide their circumvention of the Sunshine Law. Neither lady rebutted my allegation of the discussion or Commissioner Kaufman's go-in first comment. I'm currently not seeking any further accountability for the commission other than the minutes to properly reflect the discussions that occurred. Thank you.
Thank you, Mr. Ream. Okay, so do we have a phone going off somewhere?
Can you hear me?
We can hear you. Go ahead.
Hi, this is Rick Gonzalez. My phone is finally working with the webinar.
Terrific. Welcome, Rick. Good to have you. Okay, so we just received public comment on approval of the minutes. Director Lotane or Mr. Morris, is there a way that we can take the recording that we have of all of our meetings and make it an official part of the minutes and make sure that it's available to the public, so that while the written minutes might not completely encompass every single part of our meeting, the public will have complete access to everything that's said here, as long as it's incorporated as a part of the physical minutes. Is there a way that we can do that?
Yes, that's actually easily done. And we've actually done that in advance of this meeting because we knew there might be some conversation about the minutes. Jeremy, can you show that on the screen? I think you have a copy of it. Essentially, the link to the webinar, once the webinar is completed, becomes the link to the public recording. So what we did, for your consideration as well, is we've added the link to the heading of the minutes, which the ones that were sent out previously didn't have the link, with a note at the bottom that is a recording, audio visual recording can be accessed via that link.
Okay.
That you can see up there. So that would be, staff did that thinking that that's the easy way for everyone, the public and the commission included, to be able to link to the recording of the webinar.
Okay, well, we have a go Mr. Morris, go ahead.
Just to further weigh in on that, that's for consideration for the board, but you still also need to take minutes, an official recordation of the meeting. You still have to have minutes in addition to that, so it's still on the table.
Sure. So we have a motion. Mr. Cortez, go ahead.
Sure, I wasn't at last meeting, so I can't comment on what happened and didn't happen, but I trust the staff to summarize in the form of minutes. So I'd move for the adoption of we already have that a motion on the table, John?
No, I think we need to have a discussion.
Go ahead.
I'd like to see who initiated the proposed changes. Were these initiated by you as written? I would like to have the commissioners who are referenced in these changes speak to them before we vote on the adoption. Particularly, well, Commissioner Bentz is not here, but Commissioner Kaufman is here.
Go ahead.
Mr. Phelps, just to clarify, those minutes that you have in front of you that with the changes were not proposed by us.
I understand. I got that reference. Okay, yeah, right. Thank you.
Thanks, John. I did not discuss the fossil permit on the break. We weren't discussing anything that was up for a vote by this board. I don't really recall, but I could be wrong. I don't recall us requesting staff come back with recommendations on how to end the program. I don't recall that at all, and I don't think we voted on that.
Are these underlined? These are the additions, since I'm looking at item 7A, and it seems that we have on page 2. Are those new additions from what we originally had?
I believe that is what Mr. Ream had proposed. That's not what staff proposed.
On page 2.
On page 2, the underlined.
Yep. The underlined portion that's also bolded is the first recommended change.
Okay.
What is on the screen is what staff had proposed as a resolution, is to add does not have the language that you're referencing, Mr. Dustin. We had just recommended that we could include a link to the recording so that anyone could click on that and get to the recording and hear the entire what transpired at the entire meeting. What you have in your hand is what Mr. Ring brought.
I see. Okay. All right. So what I've got right now as the chair is I have a motion to adopt what is proposed over here, including the official link, which would give a recording of the entire discussion that was obtained in November at our November meeting as an official part of that.
Well, I would ask, maybe Mr. Cortez could clarify, were you proposing to adopt that version or the version that is in front?
Proposing to adopt the minutes as presented by staff.
Okay. Okay. So as proposed by staff with the official recording incorporated, and second still stands? Okay. Any further discussion? Seeing none. Mr. Ream? So I'm going a little bit out of procedural order by allowing the following questions. I don't really have a whole big problem. Mr. Morris, if you have already had that discussion, if you want to make to talk with him separately about your legal opinions about his issue, I mean, you can do that or you can state it now, but if you don't have anything, I mean, we'll just move on. And Mr. Ream asked a question. He wasn't near the mic. If you can rephrase what he just asked.
I believe Mr. Ream asked whether or not the minutes have to be accurate as to the discussions that were held. I think ultimately it's the commission's responsibility with the Division of Historical Resources as staff to come up with a brief summary of the discussions that were had at the meeting. You'll all take a vote on whether or not the minutes accurately reflect what occurred at that meeting. It's not particularly, it's not a judicial determination as to whether or not those are accurate or not. They're the board's summary of the discussions that were had at the meeting. And I think including the verbatim transcript,
that's a backstop
recording as the official recordation of the meeting is helpful as well.
It's an idea of a guarantee that we might debate what is accurate, but there's the official recording. So that's where if anybody wanted to debate, you lean on that.
Question, Mr. Chairman, if I may, of council. I believe in the past, it's been our practice primarily to focus on actions taken on which there was some kind of vote taken by the council, not discussions as such generally. And I believe that's been satisfactory to the commission up to now. Now, if you want to include discussions in the minutes, then you're setting a precedent now that I think would result in potentially voluminous minutes that would not really go to the question of the actions taken by the commission, which is our principal function.
Yeah, we'll certainly look at that.
I agree with that statement. I've been on this board for 18 years, and I'd hate to change the way we've been doing this when it's been working so well for the past 18 years.
And we'll certainly take that back and look at it. I don't believe the structure of the minutes has changed substantially. I know staff is the one that puts them together, but I believe we are required as a board to provide a brief summary of material conversations that occur at the meeting. But obviously it's not required to be a verbatim transcript, and certainly recording the votes that take place is, the principal responsibility. But I believe we are required to also include a brief summary of conversations that are had before the commission.
Mr. Chair, if I may.
Yes, Mr. Hoyt.
Thank you. I would say certainly agree with all the recent comments that were made. I would also add that, as board members are, in my understanding, and I'll defer to anybody who understands parliamentary procedure and sunshine law better than I do, but we're not under no obligation to respond to public comments. I would encourage our fellow board members to refrain from recounting specific things that happened, especially in light of the fact that a sunshine point has been made. And, you know, a summary of any conversations is only necessary, according to my understanding, for things that are discussed that are likely to, or that are going to come up for a vote. So I think the way that we've been doing it seems fine to me.
Thank you, Mr. Hoyt. Any other board members, commission members weighing in? So we have a motion, we have a second. Angie, any other comments before we vote?
Just could I ask who made the second on adopting the minutes as presented by staff? I missed that. John, thank you.
John, okay. All right. I don't see any further discussion, so let's vote. All in favor?
Aye.
All opposed? Okay, motion passes unanimously. So, item 5, presentation of sunshine law and public comment. Legal counsel, you have the floor.
Thank you, commissioners. These are codified in our statutes. For what you all are particularly needing to know would be Chapter 286, which is relating to open government public meetings. Codifies in law that meetings at which official acts are to be taken are declared to be public meetings open to the public at all times. And we are required to take minutes of meetings at which official action occurs. Those are to be promptly recorded and then approved at the next meeting of the commission. Relating to open government meetings, the scope of the Sunshine Law applies to advisory boards created pursuant to law, ordinance, or otherwise established by public agencies or officials. So you all are subject to Chapter 286 as a commission that's created by law. Some of the prohibitions that are included in the Sunshine Law, board members may not engage in private discussions regarding board business with each other, either in person, by telephone, email, texting, or other electronic communications. So if it's board business, if it's gonna come up before the board or reasonably come before the board, there should not be discussions outside of the sunshine on those matters. While an individual board member is not prohibited from discussing matters with our staff, we cannot be used as a liaison to communicate information between board members. So you can't say, hey, Alyssa, tell this person I want to do this. But we can certainly have individual discussions with commission members to ensure that the items that need to be brought before the commission are brought. There are potential violations for violations of the open government requirements in Chapter 286. There are potential civil penalties, potential criminal penalties for knowing violations. Those are all contained in Chapter 286. The second part, which doesn't pop up very often for you all, but is certainly good to know, is the public records responsibilities.
All right. So earlier in the meeting, Commissioner Kaufman said, I don't recall us recommending to eliminate the fossil program. So I went back and I listened with my AirPods to the meeting to give you guys some context to what took place. So Commissioner Phelps asked who sets the $5 permit fee and said that the commission should find out in order to revisit it. Chair Bentz said it should be stopped, and Commissioner Phelps suggested the commission try to get it raised to a point so that no one participates. I'm paraphrasing. Commissioner Kaufman jumped in and said that it would be a great use of the commission to identify an issue and update it, that is, get rid of the program. Chair Bentz commented, if we did that, it would bring a firestorm, just like when the IFP was killed. Commissioner Phelps responded and said that they should ask staff to make an inquiry regarding the discussion. And shortly after that, I asked to give comment and was told, to wait till the end of the meeting for procedure. Shortly after that, we went to break, and what happened was during public comment, Commissioner Kaufman stated the following: because I alleged that Commissioner Kaufman and Chair Bentz during the break had gone to a separate room, I overheard them discussing the fossil permit program. Commissioner Kaufman stated, I told Chair Bentz I was glad she said the comments that she said. She was concerned she may have said too much, i.e. the firestorm. And I said, no, I don't think so. I really want this issue to come back to the next meeting. And then she reiterated, I'm glad she brought up the things that she brought up. Today, Commissioner Kaufman said, I didn't discuss the fossil permit program with Dr. Bentz. Here's kind of the legal issue. The admittance that Chair Bentz and Commissioner Kaufman discussed the program offline during break, that is a misdemeanor. Saying today that she didn't discuss the fossil permit program with Dr. Bentz during the break is a felony under Chapter 817.155. You can look that up later. So basically what you've got is Commissioner Kaufman, it would be in her best interest to clarify her comment from earlier in the meeting and basically bring it back down to the misdemeanor level as opposed to the felony level. So to give you guys a little bit more background, why do I keep coming? It's because for the last 5 years, DHR was trying to subversively, through staff, kill the fossil permit program. That's how this all started.
Shereen, you got about 10 seconds, and I'll give you a little bit over the line, so just try to wrap it up.
That's what I've got. These are the facts. You can go and listen to the recording yourself and see that these conversations did take place, which under Florida statutes is a misdemeanor.
Okay, thank you for your comments, Mr. Ream. Do we have any other public comments? Seeing none, we'll close that portion of the meeting, which brings us to adjournment. Seeing no objections, motion to adjourn. The meeting is so adjourned. All right.